Hi, welcome to Is That Even Constitutional? This is a show where we use the lens of the Constitution to dissect current events selected from recent administration actions, from headlines, listener questions, or interesting legal issues that we identify ourselves. My name is Sadhana Devaraja, and I am not a constitutional scholar, but lucky for me, my good friend Ken Thomas is. Hi, Ken. How are you?
Hey, Sadhana. How are you doing?
I am doing all right. Every week we will be in conversation to dive deep on a new topic. And today we are going to talk about something that's been in the news, which is the federal administration threatening colleges and universities by pulling federal funding from them, especially if the colleges and universities aren't abiding by new terms, or they're not perceived to be abiding by new terms that the Trump administration is setting. And so most recently, the media has been covering what's been happening at Harvard. So to get us started in that conversation, Ken, can you tell us a little bit about what is happening at Harvard?
Well, I guess we should start by saying that, and I believe it was 2016, President Trump said that if he was walking down Fifth Avenue and he shot somebody, that he wouldn't lose any votes. So I don't think we should be that surprised that here we are in 2025, and President Trump has essentially now frozen billions of dollars that will not be made available to Harvard University, and doesn't believe that he's going to lose any votes because of this. So what has happened is that Harvard University has been informed by the Trump administration that several billion dollars worth of federal research funding, which is going to very specific research that is going into Lou Gehrig's disease, radiation sickness, tuberculosis, will not be made available. So right now, if Harvard is asking for these funds to be provided in response to specific goals being met or specific contractual parameters being met, then the Trump administration is refusing to provide those funds. And this is not just Harvard. This is actually, there are several institutions that appear to be affiliated with Harvard, but not actually under Harvard's control, hospitals in the area that are being subjected to the same provisions, essentially saying that the federal government is not going to provide the money that has been previously allocated to those institutions for federal research.
So I think the first question that I have is, can the administration even do this? Is that allowable? And I'm presuming they think they can. And so how are they doing it?
So the withdrawal of federal funding is actually one of the most powerful weapons in the federal government's compliance quiver. And what's interesting about this is that it's a additional compliance requirement that a lot of people aren't necessarily that aware of. Obviously, we're aware of their federal law provides for criminal law, for civil law, for various ways of enforcing institutions to comply with the law. But one thing that is very, very significant is if you receive federal funds, then the federal government can impose conditions on those funds. Now, obviously, a lot of those conditions are directly related to things like how you are spending those funds. So, for instance, if you are going to spend those funds to research tuberculosis, you can't then use it to research the common cold. These are called federal funding conditions. An additional aspect of federal funding is that there are requirements that are often imposed on institutions receiving federal funding that don't seem to be as directly related to the funding being provided. So, for instance, the Civil Rights Act of 1964 and other relevant acts are often tied to federal funding. This is actually an outgrowth of the fact that the Constitution really only reaches discrimination by the states and by the federal government, but doesn't really reach it by private institutions. And so by taking federal funding away from institutions that are engaged in discriminatory behavior, this is a way that the federal government can reach private actors who are engaging in civil rights violations. And this is an example where the federal government actually has a lot of power. But what is interesting here is that this almost never happens. It is very, very unusual for the federal government to take federal funds away from an institution because of alleged violations of civil rights laws.
All right. So it sounds like, as existing kind of ways that these grants work out are that the federal government gives the university money for research. They, through that, can tell the university what research needs to be done, and the university needs to comply by that. This is how research funding has worked for many years, and the compliance could be in terms of the type of research that needs to happen, as well as to make sure that they're furthering federal laws that have been enforced, like civil rights laws. So I think that makes sense. And so I think part of this, though, is that usually that is conferred through the power of Congress, right? Not the president.
That's exactly right. And so what we're really talking about here is the power of the purse. The power of the purse is the ability of Congress to tax, spend, and of course borrow, which is another way of getting money into the federal coffers. And this is an Article 1 power of Congress. It's really one of the most significant powers of Congress, and it is really very much exclusively a power of Congress. It is not a power of the president. The president cannot just raise taxes by himself, decide how to spend money, et cetera. This is something that Congress does. So where we get into a gray area is where the Congress has raised money or has provided money that is available, has provided it, and then gives it to the president, and then gives the president some degree of authority in how that money is going to be spent, and also gives the president the authority to enforce grant conditions that the Congress has put on there. And so the basic point here is that we're talking about Congress has to set the conditions for what the limitations are going to be on this federal funding. And the reason that I'm emphasizing the power of the purse is that when Congress provides federal funding withdrawal as a penalty for failing to, for instance, comply with Civil Rights Act, they have always done that with a sense that this is by far the last possible resort for the executive branch to bring. And there is a very specific set of statutory proceedings left that are in the Civil Rights Act. And there are also several of these things are also in regulations that provide explicitly what has to happen before money can be taken away. Again, this is just an indication that Congress wants this authority to be there, but they don't want this authority to be used arbitrarily. So in the case of the Civil Rights Act, there is essentially a requirement that you have an internal judicial proceeding. This was actually the first job I had out of law school. I was a litigating attorney for the Department of Education Office for Civil Rights, and we would bring cases in front of administrative law judges, meaning these were not judges in the federal courts. These were judges who work within agencies. And there would be a trial very similar to the trials that happened in the federal court, but they'd be within the agencies. They were a little less formal, and we would have to bring a case in front of that judge. And so, for instance, if we were going to bring a case against Harvard saying that they were violating the civil rights laws, then we would have to present information. We would have to put on witnesses. We would have to provide evidence. Harvard could come in. They could hear that evidence. They would have counsel there. They could introduce their own evidence. They could cross-examine. Everything would be ultimately decided on the record that was before the judge, and then this could all be appealed to the federal courts. This is a process that goes on all the time, has always gone on all the time. All the agencies know how to do it. That was not done in this case. The executive branch stopped paying out federal funds without going through any of these procedures. It is absolutely in violation of the power of the purse requirements that Congress imposed.
That's Fascinating. So what you're saying is, taking the example of the Civil Rights Act of 1964, that that's one of the laws that the universities and colleges need to abide by to receive their federal funding. And if the claim, as it is here, is that Harvard University is in violation of the Civil Rights Act of 1964, then there's a process by which they can appeal that, or there needs to be kind of an adjudication on that point before the federal funds are withdrawn. Is that right?
That's exactly right. And so what's going on in this particular case is that the administration is essentially accusing Harvard University of violating the Civil Rights Act of 1964 because they're engaged in anti-Semitic activity. And this is essentially because of protests surrounding the war in Gaza and how the various colleges and administrations within Harvard University reacted to those protests. The theory is that the Civil Rights Act of 1964 was violated because Harvard University acted in a fashion towards these protests that in some way was discriminatory. Now, there's a couple of problems with this. First problem is that there are obviously free speech rights involved here. And so if Harvard University was dealing with protests and the federal government is saying, no, Harvard, you shouldn't have allowed these people to speak, then that is impacting on some free speech rights to begin with. More problematic is that the requests that the federal government is making to the Harvard University seems to go well beyond specific allegations of anti-Semitism and is going into some very specific aspects of Harvard governance. So, for instance, the Trump administration is essentially saying you need to fire people that we think are not properly articulating a particular political viewpoints. You need to survey your entire faculty and see what their political viewpoints are. You need to start hiring faculty based on their viewpoints. You need to start admitting students based on the viewpoint, and you need to essentially start dropping classes based on the content of their viewpoint. These are so clearly intruding on First Amendment protections. Now, obviously, there's always this interesting dynamic between the Civil Rights Acts and free speech, because to some extent, free speech does have the limitation that you're allowed to say things, but to the point that you say things that become discriminatory, that's a limitation. However, this is a very, very difficult, fraught with peril issue that would usually be resolved in courts after years of litigation, not arbitrarily decided by an agency official with absolutely no internal proceedings. This is very much like having a police officer arrest somebody, put them in jail, and then execute them. This is not legal procedure. This is not the way things are done. This is essentially a form of anarchy in our legal system. It is not the case that agency officials get to remove the ability of Harvard University to get money without going through any of the required processes whatsoever.
And so I think you've been really clear that there are kind of a number of violations of the Constitution, including the First Amendment, including Article 1. And what's happening here, and something that I think has been dominating a lot of my conversations, is like, well, is the strategy working anyway? So there's this legality of it, but would you say that it's working despite the illegality?
So one thing about the American legal system is that there's a certain abstract beauty in academic discussions such as we're having, and then there is the reality. The reality is that the American legal system has something called the American rule. The American rule, which is pretty uncommon in the world, is that every side bears the costs of litigation. So that means is that if you are defending yourself against the federal government, except in certain cases, you are going to have to pay for those costs. And so if you are a university who believes that you have been wrongly denied a grant, and then you have to spend millions of dollars to get that grant, which might not have been worth that many millions of dollars to begin with, then the incentive for you to sue is low. And so for this case, for this reason, the opportunity to litigate may actually be one that's just not realistically available. So some universities are just going to decide it's not worth it. Columbia University was threatened with the withholding of millions of dollars worth of grants, and they responded by saying, we will change our procedures regarding protests, regarding security. There is even some indication that part of the reason their money was being withdrawn was because there was a transgender athlete on one of their swim teams. So there's the lingering threat that is an issue they're going to have to deal with. And so essentially, unless you have a lot of money and are willing to make a stand based on spending a lot of money, it's really going to be hard to fight this. And so in many cases, a university or other federal funding entities are not going to be able to go forward. Even somebody like Harvard, who has a multi-billion dollar endowment, is not as rich as it sounds like. Endowments are actually indications not of free money waiting around like in a checking account, but in many, many cases, and I believe in some schools it's as much as 80%, this is money that has been given to a university for a specific purpose. This money is given for engaging in certain types of research in order to endow chairs in particular institutions. It is not money that the Harvard would just be able to use for instance, for litigation costs, in order to backstop research that's going on in other situations. And so by Harvard making this kind of strategic decision, which they have made, which is they have already sued the federal government, they are essentially making a commitment of vast legal resources to fight what shouldn't be a particularly difficult case to litigate, but it doesn't mean it's not going to cost them a lot of money.
Yeah. And I think that I both understand some of the difficult decisions like you're describing for these institutions that have these real federal funding threats and other funding threats at their door, and also think this may be an opportunity for them to recognize the power that they do hold. And so I know part of what has been in the news earlier this week was the AAC&U, which is the Association for Colleges and Universities, put out a public statement where they had, I think, at this point, over 200 colleges and universities take a stand for what they for how they feel like they need to be showing up in the moment. And I think that's not the end game here, but there are these new ways of kind of sharing power and recognizing that each of these universities held together may have a lot of power to change the tide of the strategy working anyway, especially if they're not looking at it university by university, but thinking how collectively they might be able to do a different type of push against these real legal threats. So I think one of the questions that has also been coming up is, so what does this mean for students right now at the university and otherwise?
That's a great question. My son, it turns out, just applied to a Harvard research lab for a job, and we were a little concerned about that. He did get it. And one reason we were concerned was that we thought that Harvard would be limiting the ability of people to work there. But it turns out my son is essentially just going to be taking care of a small frog that is a research animal. And so consequently, keeping the frogs alive does not appear to be a federally funded mandate. And so he will continue to work there. However, to the extent that these freezes go into effect and remain into effect during the litigation, then there may be fewer doctoral students admitted to these institutions. And if there are fewer doctoral students, then that means that there are potentially fewer doctoral students to teach undergrads. That means that there may be fewer opportunities to take classes in science. There may be fewer opportunities for science at these particular institutions. So I think, at least for the research grant aspect of this, this could have a direct and immediate impact on the ability of students who want to seek science educations at institutions who are being targeted of being able to do so.
Yeah, and I think this is really also the narrow focus of how this particular research funding is being pulled. I think there's kind of a polycrisis in effect here at universities where there's funding threats through different vehicles. And so just want to pull that up too. There's NIH funding cuts, there's CDC funding cuts, there are all these other funding cuts that impact universities and colleges as well that might be um, kind of compounding the problem that students will be facing, and not only through these kind of funding pools that we're talking about here. And so that kind of employment opportunity and the scientific inquiry opportunity is much greater than even this piece of the pie that we're dissecting here today. So are there other examples of withholding funds that the federal administration is taking without the process that we would expect in our legal system?
So there's actually a long-standing issue. This actually started in Trump 1 and is continued in Trump 2, and that's the issue of sanctuary cities. Now, sanctuary cities is an interesting issue, especially because nobody knows exactly what a sanctuary city is. The federal immigration process is actually something that is pretty much it's a federal reserve. It's something that's only enforced by federal courts. The arrest authority for immigration violations is really only given to federal officials, and the states and localities really have no official part of that process. And so for states and local entities not to be deeply involved in the immigration process is not that unusual. Having said that, sanctuary cities have essentially gone a step further and essentially removed what would be perhaps more informal processes where there would be cooperation between the state and city government and the federal government on immigration issues. Now, some of these are for political reasons, some are for practical reasons. So, for instance, if city and local officials get involved with immigration, then it's hard for those city and local officials to serve their community, which might include a mix of undocumented and documented immigrants. And it might be hard to do police work, to do social work, outreach, et cetera, because if nobody's going to respond to a knock on the door from anybody wearing a uniform, then it's going to be very hard for people to work in those communities. And so sanctuary cities have made an effort to create essentially a separate system with state and local officials where undocumented immigrants are not going to be particularly concerned of interacting with those officials. So some of the things that a sanctuary city might do is tell their people not to inquire into people's immigrant status. So, for instance, if there is some kind of traffic accident or there is some kind of law enforcement situation, then the state or local official does not immediately ask for the person's immigration status. Now, that issue might come up later, but we'll talk a little bit about that. And the local, state and local entities will not necessarily go out of their way once they do know somebody's undocumented status to inform the federal government that the person is undocumented and should be put into some kind of detention. And one reason for that is that actually, realistically, the federal government does not take most people who are undocumented into custody, for deportation, unless generally there is some other reason too, such as they've engaged in some kind of a crime that makes them eligible for immediate deportation. So, sanctuary cities are a group that is essentially not necessarily doing anything particularly wrong, but it's a group that has come under some scrutiny by the Trump administration. So what the Trump administration did under Trump 1 was they took a law that said no city may prevent its own employees from contacting the federal government with immigration status violation. Well, it's not clear how many cities actually do that. They certainly make a policy not to, they'll tell people not to seek out somebody's immigration status. But that law by itself does not really impose a lot of responsibility on most sanctuary cities. However, in the first Trump administration, the argument was made that, well, unless the states are affirmatively agreeing to provide information, then they're in violation of that law, and we're not going to give them federal funds. And they started with Department of Justice funds. Almost all the courts who saw that immediately struck it down, saying that law has nothing to do with federal funds. And pretty much that all ended in the first Trump administration. Well, it's been brought back in the second Trump administration, and now they're applying it to other federal funds. For instance, they said recently a sanctuary city, if they want transportation funds, they're going to be deprioritized and they'll be put at the end of the line because they're a sanctuary city. And this is essentially a law that has nothing to do with federal funding. Consequently, you can't use it as a way to withdraw federal funding. And again, we're getting into the power of the purse here. Is if the federal government says, or if Congress says, we've passed this law, the penalties are this, the president can't just say, oh, well, we're now going to also make that a federal grant condition. That is not within the power of the purse, but it is something that the Trump administration has basically brought back onto the table despite negative litigation in the past, and is enforcing against cities and states. So this is essentially a second time around. And of course, there's going to be more litigation over this. And it is, again, something that is going to cost a lot of money. And one thing that has to be kept in mind here is that a lot of things that are being done in the name of cost cutting are actually ending up costing the federal government a lot of money because of litigation costs and because of various other related administrative costs.
What's, I think, kind of ironic about what you're describing is that this definitely feels like the federal government is really trying to exert more power on what happens within states and localities. And aren't the Republicans the ones that believe in states' rights? So how is this kind of consistent with the philosophy?
So I worked on Capitol Hill for over 30 years, and I think a very, very consistent theme of the Republican Party, and when I say consistent theme, I'm talking about Republican Party platforms, legislation, hearings, really a very unified agenda, was the idea that states should not be made to be agents of the federal government. And this made, the argument in the context of regulatory things, it was made in the context of spending, it was made in really many, many contexts. And this is why we ended up with a lot of block granting of agency funds. The idea is, well, the Fed shouldn't tell us how we should spend our money on this particular program. Just give us the money, we'll figure out what to do with it. This was a lot of de-evolution of power from the federal government to the states. And certainly there is a very, very strong argument made that unfunded mandates on states were a bad policy idea. The idea that the federal government tells states, you have to regulate this, you have to enforce this, you have to run this program, but we're not going to give you any money to do it. And the idea being is that the federal government was kind of getting away with a hidden subsidy that the feds could pass a policy, but then the states had to be the ones to raise taxes and pay for it. So this is a very, very consistent theme, not only of the Congress, but also of the Supreme Court. We had what was considered to be the federalism revolution, which was I want to say the central piece of Chief Justice Rehnquist's Supreme Court was the idea that the congressional power to make states and cities do what the federal government wanted to do is something that had to be limited. And there are some very significant court cases, really kind of groundbreaking, saying that, for instance, in New York versus United States, that the Congress couldn't tell state legislatures that they would have to regulate in an area that Congress wanted them to regulate. In that particular case, it was the regulation of low-level radioactive nuclear waste, and Congress just didn't want to do them themselves. They want the states to be the ones to regulate it and then to take responsibility for it. And the court struck it down, saying, we just don't see that in the Constitution. Interesting. It was kind of a, I don't know, anti-textualist argument in the sense that there was nothing in the Constitution that said Congress couldn't do it, but essentially the court struck it down. And then for U.S. versus Prince, the federal government had tried to get state and local authorities, such as police officers, to do background checks for a federal gun background check regime. And the court said, no, you can't commandeer state and local officials to do your bidding for a particular regulatory program, and struck that one down too. So very much a theme of the Republican Party. Interestingly enough, the one exception that's really pretty much has always been there has actually been the grant conditions for federal funds. That's because there's this idea that it's voluntary, which is that if a state doesn't want to comply, then they don't have to take the money. There was actually a little bit of concern around that after the Affordable Care Act. There, an exception was made if it's a really, 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 really a lot of money, as in that case the Medicaid was. But in general, the idea is that if states don't want to be commandeered, then they just kind of can leave the money on the table. Of course, in most cases, that's not very realistic either. So this is an example of where now cities and states are essentially being commandeered to do something that is clearly a federal responsibility, which is immigration law. It's something that the feds have jurisdiction to do. They have the background, the knowledge, and authority to do. And if they feel like they need more resources, they have the ability to raise taxes and to spend money to facilitate their resources. They don't need to make the local entities do their work for them. And so again, this is kind of a little bit of a backsliding on the idea that states should be able to choose whether or not they backstop the federal government for their regulatory programs.
So I think we're kind of close to closing here. Wondering if you could kind of just sum up, what really is going on here then.
Well, I think this is another example of where the Constitution and the various relationships between power and how power is exercised in our constitutional scheme, there are a lot of opportunities for, shall I say, constitutional mores to be broken down. So the idea that this very, very powerful federal funding stick was always in the background was that it was always in the background, and that was a useful thing, but it remained in the background. And even if sometimes it was maybe, a big, big, big stick, it was still in the background. The idea that now executive branch decisions are going to be made in such a quick and unregulated way is not only not only be alarming for people who are concerned about what this administration is doing, but it should be alarming for people who would be concerned about what an administration that might have a different ideological bent could be doing. We could see the kind of whipsawing back and forth between the requirements that the federal government is imposing on somebody that would completely devastate our rule of law and devastate the kind of stability that our country generally relies on for economic stability, for democratic stability. It's a very destabilizing thing. The law is slow, it is tedious, it is difficult, it is expensive, and its big benefit is stability. And if you don't like stability, just wait until you see the costs of instability. They are far, far more extensive and more expensive than those of stability.
Thanks so much, Ken. So today, we covered through the lens of the federal administration's targeting of Harvard and other institutions, the power of the purse that the Constitution gives Congress and not the president. And we talked a little bit about the legal or maybe not legal basis that they're using for action and the impact on other universities as well as on students. You gave some examples on sanctuary cities and kind of overreach that's happened there and the hypocrisy that we're kind of living in through this vehicle. And kind of closed us out with how this is a lawless power grab. So thank you for bringing light to this issue, and it's always great chatting with you, and I'll see you next time.
Thanks, Sadhana.